Am I going up just to please you? I just want to remind you about tomorrow, because we're going to hear from a number of people early in the morning, 10 o'clock. It'll be our second panel, and Mr. Ferencz will be in charge of it, and some other people from the prosecutors in the subsequent trials will be available and will give little talks, and I think it's going to be a memorable thing to show another aspect, a further aspect of what we've been talking about today. So please do arrange to have your breakfast and get here by 10 o'clock sitting down. So come early, please.
I have promised our Führer, Sprecher, that I will abide strictly by the program, and that you will all be relieved to know that you will get out of here in a good time. If I wasn't here, it was not because I was loafing. We were doing a broadcast for National Public Television, and Mr. Rockler, who was part of that program, had a call of nature, and he refused to do it under the table. So I gave him a minute off to go to the men's room. I am not usually so tolerant, as these following speakers will soon discover. We are here to deal with the subsequent proceedings at Nuremberg, which did not have all of the glamour of the first international military trial, but is all the more important because the public needs to be educated a little more on the 12 subsequent trials for which Telford Taylor was the chief of counsel. I had to rush through here. I don't know whether Telford had the good sense to stay in his room or whether he's
right
here. Wherever he is, I extend greetings to Telford Taylor, who should be standing here. Just as Justice Jackson was the inspiration for the IMT trial, General Taylor was the inspiration and the guiding light for the 12 subsequent trials, and the years now compel him to be a member of the audience, listening to the accolades which we'll have about him in due course in this program. And I'm sure I can't educate him on these trials, but we will try to deal with the 12 subsequent trials. And each of our speakers has been allotted 15 minutes, since there are 4 of us. If you can't survive 15 minutes, you can scream. I have told them that if they exceed 15 minutes, they won't survive. So, Belle is saving her strength for her old age. So what we're going to do is we're going to allow her to begin her presentation about the Industrialist Trial, and I will move this podium to be out of the way, and so you'll have a better view of her, and I turn the chair over, the floor over to Belle Mayer. Thank you.
Thank you, Ben. In talking about I.G. Farben, I must tell you that I am very inhibited by the presence of Drexel Sprecher. I thought I had some familiarity with I.G. Farben from my early years at the Treasury, U.S. Treasury. And I did work on the presentation of the case in Nuremberg. But after the first count, crimes against peace, that is aggressive war, after that was presented to the court, I left Nuremberg. Drex, on the other hand, knew every aspect of the case from beginning to end. And not only that, but he selected, edited, collated, and published the 2 volumes on I.G. Farben. And he did the same thing with all of the trials and subsequent proceedings. But the volumes on Farben, 7 and 8, which I commend to you, are that thick, 4 or 5 inches thick. You can appreciate the enormity of his work. It reminds me of a story about a man who was one of the few survivors, if not the only survivor, of the Jamestown flood. And for years, he would corner anybody and everybody he could meet to tell him the story about the flood. But after a while, excuse me, people got fed up with his repetition. They would no longer listen to him. They avoided him, and he died a very lonely man. When he died, he went to heaven. St. Peter greeted him very cordially, and he said, Peter said, "You've been a good man, and God has told me that he will grant you any wish you might have." That made the man happy. And he said, "Do you think that God could gather together all the great in heaven?" He said, "All the poets and writers and princes and kings and saints and prophets, and listen to my story about the Jamestown flood." Peter said he'd see, and he went away and came back in a short time and said, "God has granted your wish. He has assembled all of the mighty in heaven, and your audience is awaiting you." The old man was delirious with joy. And as he turned to leave Peter, Peter said to him, "Incidentally, old man, God told me to tell you that Noah will be there." For 50 years, I found it very difficult, if not impossible, to talk about I.G. Farben. If Benny would give me an hour or 2 hours instead of 50, you're not going to hold that story against my time.
Counsel, you've got 12 minutes left.
I really couldn't do it justice. Moreover, it's kind of futile to talk about a lost battle. And my generation's of lawyers, I must tell you, consider to this day that it's bad form to blame the judges. I must say, though, sitting in the United States, as I said before, the acquittal of all of our defendants on the aggressive war charge shocked me. But I was really stunned by the court sentences meted out to the few defendants they found guilty of crimes against humanity and old-fashioned war crimes, which had been war crimes since 1897. I'm talking about slave labor, poison gas, and medical experiments. As many of you know, but some of you don't, there are people here who've never heard of I.G. Farben. I.G. Farben built its fourth synthetic rubber plant at Auschwitz, which was one of Himmler's largest concentration camps, because of the availability of cheap labor. There, under Farben's dominion, and under the dominion of the SS, they were starved, tortured, in many cases, beaten to death. Now, I'm talking about not only about the poor Jews and gypsies, I'm talking about Polish workers and Belgian workers and French and workers who had been plucked out of their native countries and taken to work in the factories in Germany and in Auschwitz. It's estimated that 25,000 people alone died that 25,000 people died in the construction of the camp alone. And hundreds of thousands of peoples of all nationality died subsequently of starvation, torture, and in many cases were just shot by the SS. And they were no longer useful. employees of I.G. Farben circulated a memorandum justifying the use of the SS. He said the Belgians and the Poles don't say very much, but they get a very surly look on their faces. And he said it's necessary to, quote, discipline them. Then he said the gypsies, he said, and of course, we cannot tolerate the Jews and the gypsies. He didn't say the way many of us say about other people. He didn't say they're intolerable. He said we cannot tolerate them. I'm not going to continue with the longest sentence in this, on the count of slave labor, the charge of slave labor, was 8 years. That was given to a man named Otto Ambrose. Termeer, the chief scientist of I.G. Farben, got 7 years. Crouch and, well, all of the defendants were given credit for the time served. So immediately after the decision, they were discharged from prison. Then, in 1950, John McCloy, who had become High Commissioner of Germany, and his clemency commission commuted the sentences of all the defendants in all of the industrialist cases. To get back to atrocities, I'd like to give you just one example of the nitpicking that went on by 2 of the 3 judges who tried the case. And that has to do with the medical experiments. To test the efficacy of Farben products, medical experiments were conducted on concentration camp inmates. As a result, many of them died, and most of them in incredible agony. Farben's defense was that when they shipped their vaccines of poisons, such as methylene blue, to the concentration camp doctors, they didn't know that the doctors were going to use them for illegal purposes. The court said, we find nothing culpable in the circumstances under which quantities of vaccines were shipped by Farben concentration camps, since it was reasonable to suppose that there was a legitimate need among the starving and sick people in the camps, that there was a legitimate need for such drugs in these institutions. The question of Farben's knowledge resolves around the proper translation of the word Versuch, V-E-R-S-U-C-H. The prosecution says that Versuch means experiment, and that the use of this word in said reports was, quote, notice to the defendants that testing physicians were indulging in unlawful practice with such drugs. The defendants contend, however, that Versuch, as used in this context, means test, and that the testing of new drugs on sick persons under the reasonable precautions that Farben exercised was not only permissible, but proper. Applying the rule that where, for credible evidence, 2 reasonable inferences may be drawn, one of guilt and the other of innocence, the latter must prevail, and we must conclude that the prosecution failed to establish that part of the charge here under consideration. Now, if there is a linguistic specialist here who can tell me the difference between testing and experimenting, I'd be very grateful. The thorniest problem the prosecution had in making its case on aggressive war was to show how unique IG was. Without Farben, it's doubtful that Hitler could have taken Austria, the Sudetenland, Czechoslovakia, let alone conquer all of Europe. Rumor had it that one of our judges, before he heard any of the evidence, had said that he couldn't see the difference between I.G. Farben and DuPont. He became increasingly impatient as we introduced hundreds of documents and charts on organization and size and worldwide subsidiaries. To him, size and worldwide influence and the major source of Hitler's foreign exchange, namely U.S. dollars, were immaterial. To him, the stockpiling from abroad of critical war materiel years before the war broke out was immaterial. To him and one of the other judges, I.G. Farben's worldwide influence merely showed they were big like Standard Oil of New Jersey. The prosecution felt that we had to show Farben's extraordinary capabilities as the basis for the charge that they conspired in the planning, preparation, and waging of aggressive war. In the Flick case, which preceded our case, Telford Taylor, with his usual eloquence, had said, and I'm quoting, "At the threshold of this case, and because of its unusual character, it's vital that these principles be clearly understood. The defendants were powerful and wealthy men of industry, but that is not their crime. We do not seek here to reform the economic structure of the world or to raise the standard of living. We seek rather to confirm and revitalize the ordinary standards of human behavior embodied in the law of nations." How much time have I got then?
1 minute.
Oh, come on. Are you kidding?
I'm not kidding.
Go ahead.
I had gone on at great length to discuss I.G. Farben's connections with the Wehrmacht. And I also wanted to talk, and again to quote Telford, from about spoliation, their plunder of the industries of the various countries that Hitler occupied, because they marched with the Wehrmacht and the German army, and they took over and installed their commissars and management in any plant that was prosperous. If the plant was not, this happened in all over. If the plant were not prosperous, then they dismantled it and shipped it home. Well, as I told you, incidentally, on that charge of spoliation, the few defendants convicted also received insignificant sentences. As I told you, I was in the United States when the decision came down, and I was devastated. In August 1948, I got a lovely letter from General Taylor in which he said in part, quote, "I suppose that when you read the judgment, many of its features will surprise and disappoint you as much as they did all of us here. But regardless of how the judgment may be evaluated in years to come, I am sure that the record which you and Joe and the others made will be generally regarded as a great step in the development of international penal law. I have hoped so for many, many years. I continue to hope." Thank you very much.
Not to include in Walter Rockler's time, with a long introduction, praising him to the skies, I give you Walter Rockler. I give it to you for the next 1 minute. Correction, 15.
I thought you'd see the error of your ways. I came to Nuremberg almost by accident because I spent the entire war in the Pacific with a Marine League.
Microphone. Yeah, pick it up, Walter.
as a Japanese interpreter and translator on a number of islands that were taken. During the war, I had begun to lose interest in European affairs because their only significance was they were holding up the end of the Pacific War and my return home.
Walter, if you will step in front of the table, they'll see you on the other end. Otherwise, they can't see you.
I'm not sure that's a big plus.
That's the reason I put you behind the podium, but push it. Here we are. Go up there.
All right.
Okay, unless you want to stay. Okay. Thank you.
Anyhow, I applied to go to the Tokyo trials, and since I had good credentials, I wound up in Nuremberg, where I couldn't speak the language, didn't know much about what had gone on in the last 2-3 years. I didn't ask many questions when I agreed to go to Nuremberg, and I wasn't quite sure what kind of role I'd have, if any. And I arrived in what was at that time a destroyed and very strange continent. During the war, I hadn't been much in occupied places. The islands had very few inhabitants except Japanese soldiers. I got to Nuremberg, and my first assignment was to read transcripts and collect procedural rulings, which I did for several weeks. I don't know if this is coming through. It seems like it's all static. Anyhow, I finally got assigned to a projected case which had been underway, at least in the investigation phases, for a long time. An economist at the Department of Treasury, Foster Adams, who some of you may know, had prepared a report on 2 German banks, the Deutsche Bank and the Dresdner Bank. And Russ Thayer was one of the people who was working on this matter. Rawlings Ragland was then assigned to it, and Herb Goldenberg. And the bottom of that staff was me. And I got interested in the case from the standpoint of its essential novelty. The subsequent proceedings, in my judgment, across the board, reflected an application of war crimes and crimes against humanity, particularly, to all segments of German society. That was their primary function and interest. They didn't add much to the substantive law which had been announced by the IMT, although there were some embellishments. There were some judgments with respect to the standing of activities in occupied territories without war, Austria and Czechoslovakia. There were some observations by the subsequent tribunals on activities conducted by Vichy France in conjunction with their German overmasters. But I thought the banking cases were quite interesting, and I was happy to be assigned to them. I thought they were interesting from the standpoint that this did not involve conspicuous thugs and murderers. This was a case which involved an established and respectable institution of German society. In a certain sense, it was comparable to cases against German judges, cases against German doctors, cases against the industrialists, including Farman, and cases against a banker that seemed to be fit. In other words, the effect of a case like this was to establish that all segments of German society could be responsible for what happened. The first time I saw the defendants, I was kind of startled by their ordinary character. They were just people you could run into on any street in any city in the world. Nothing special about them. In the analysis of the case, we worked on both the Deutsche and the Dresdner case, and in particularly for the Deutsche Bank, we examined the activities of the chairman of the Vorstand, who was Hermann Ops. In the case of the Dresdner Bank, the chairman of the Vorstand was dead, and 2 members of the board had been SS officers. One was named Emil Meyer, the other was Karl Rockler. Meyer was also dead. That made the selection of an individual defendant rather simple. We were left with Karl Rockler. What is it that the bank could be charged with? Well, one of the documents we discovered with respect to the Dresdner Bank was an Aryanization report. It must have been 150, 200 pages long, which apparently was used by the Dresdner Bank to advertise its orthodoxy under the Nazi regime. The bank claimed to have been very active in securing, I think it was on the scale of 2 or 3 billion marks worth of Jewish property during its activities. And then, of course,
keep that thing up.
yeah. And also claimed in the subsequent period to have been very instrumental in securing German ownership of Belgian, Dutch, Czech properties on a very large scale. We had similar material with respect to the Deutsche Bank, but it was scattered. This was a single volume report by Dresdner, which, if anything, may have exaggerated their accomplishments, but at least gave us in one place a long record of what they had engaged in. The basic charge brought against Dresdner was a spoliation charge, orthodox war crimes, plunder of, in some cases, its own citizens, but that wasn't much of a crime at Nuremberg, but plunder of Czech citizens, Jews and Gentiles alike, Dutch and Belgian, and that was what they were charged with. How did they do this? The Germans didn't like simply seizing properties without legal title, so they would generally secure the owners of the property in person. And if it was necessary, they would invoke the services of the Gestapo or the SD to persuade the owners of the property, the legitimate owners of the property, to convey title for very little or no cost. This was particularly true, for example, in one case involving Louis Rothschild, who was the head of the Rothschild family in Paris. That branch of the Rothschild family owned a steel rolling mill on the Czech-Polish border, which was very up-to-date, valuable, and modern. The Germans had, of course, seized it when they took Czechoslovakia, but they wanted title to it as well. We had Louis Rothschild in a hotel in Paris with a representative of the German Ministry of Economics, Hans Kerrl, and the Gestapo. And under those circumstances, Louis Rothschild signed over his shares of stock in the Vitritz plant. He came out rather well. They actually let him get out of France to Switzerland. He survived the war. That was a major charge. A second charge was aiding in the financing of concentration camps with no interest or limited interest for the costs of construction. Ultimately, the charges of spoliation and plunder stood up in the court, convicted on that ground. They did not convict on the ground of low-interest loans for concentration camp building. That was considered a normal banking activity by at least our tribunal. Among the other defendants I had were Roche's counterpart in the Ministry of Economics, Hans Kerrl, who was similarly convicted for participating in an overall program. As soon as he got out of jail, which was as soon as the trials ended, he went about his business. And years later, I saw him in the World at War series, commenting on how bad things had been during the Nazi administration. Of course, he was a high Nazi official. I also had a case somewhat linked against the vice president of the Reichsbank, who was Funkt assistant. He was the fellow who was in charge of the vaults that contained gold teeth, gold wedding rings, gold fountain pens, gold wristwatches, anything that could be taken off the corpses of concentration camp inmates. This was not a terribly difficult case. One of his defenses, of course, was he was not anti-Semitic, and not only that, he had also protected Jews. Simultaneously, he testified that as far as he was aware, Jews were not particularly persecuted. So the real question was, what was he protecting them from? Anyhow, he was sentenced also. The effect of these cases was the 3 people who I primarily was concerned with received sentences, and I can't narrate the order of them, of 5, 8, and 15 years. The real effect, since McCloy, in his wisdom, had commuted all the sentences and nobody served any time except while the trials were on, was an able...
Keep the thing up there, because we can't hear you.
Okay, that's probably just as well.
We have 3 minutes.
I still have 3 minutes.
Yes, go ahead.
It seems to me I used up my time. Anyhow, the real effect was Emil Kuhl of the Reichsbank ultimately became a member of the board of the Dresdner Bank. So I thought his time in the dock was well spent. He had made his connections during the trial. As to why McCloy did this, I have my own theories. The whole atmosphere of the subsequent proceedings was heavily under the influence of the Cold War, and there was not so much interest in whether Germans were ever convicted of crimes as in whether the Germans, at least the West Germans, would fall into our sphere of influence and whether they could be adapted as future allies. I think the Russian position in the East was exactly the same. In other words, by 1947, 1948, there was an atmosphere of pretty much, in many circles, let bygones be bygones, let's not bother the Germans particularly. Let them come to love us and join us. And in fact, the coverage of the trials by 1948 consisted very heavily of going through the proceedings with a view to anti-Russian or anti-communist statements made by the Germans. The Germans understood this and they were not loath to make the point. In other words, the Germans seized upon what we learned to call the tu quoque argument, namely, we may have done some things that would not stand the light of day, but look at those Russians, look at those Russians. And I remember the New York Herald Tribune having a correspondent whose name was Edwin Hartridge, and looking at his stuff periodically, and what it basically had was no particular reporting of the trials with respect to Germans, but any anti-Soviet comment, whatever, was worth a headline. I guess in due course you can all ask questions.
Thank you, Walter. We want to donate that time to our next speaker, Professor Henry King, who noted that a big fellow like Walter Rockler was unable to gather the strength to hold the microphone close to his mouth. So he has decided to lean forward on the microphone where he's sitting. However, I'm sure he will rise to the occasion in his oratory. I give you Professor Henry King.
Thank you.
For the next 15 minutes.
Can you hear me?
Unfortunately, yes. We'll take that a bit.
My script today is from the heart. Let me open my heart and share some memories and feelings with you, and along the way recount some happenings which were not only important to me, but to the history of mankind. At Nuremberg, I worked on the closing phase of the General Staff and High Command case. We sought to convict them as a group, but the court found that they were not a cohesive group, although what they did had the ring of criminality. As a result, we took steps to try them individually. I was given 3 cases to prepare against German military leaders, namely one against Walter von Brauchitsch, Commander-in-Chief of the German Army, secondly against Heinz Guderian, the father of modern tank warfare and Chief of Staff of the German Army, and 3 against Erhard Milch, Goering's deputy as head of the Luftwaffe, also in charge of German aircraft production. I prepared the cases against all 3. That von Brauchitsch was handed over to the British and sentenced to a long prison term, and Guderian was to be transferred to the Poles for trial, but after we were committed to the transfer, we got into a fight with the then Polish government. Guderian got as far as Berlin, but no further, since our relations with Poland had deteriorated and prevented his transfer. As a result, he was subsequently released and returned to his home in North Germany, where I believe newspaper reports showed that he was active in some neo-Nazi activities. The remaining case which I had prepared, the Milch case, was ready for trial when the subsequent proceedings were to begin. This was fortuitous, since some of the judges had begun to arrive for the subsequent proceedings. Consequently, the indictment against Milch was served on him on November 14, 1946. On December 20th, 1946, he was arraigned and pleaded not guilty to the charge in the indictment. As of January 2, 1947, the proceedings against Milch began. The trial lasted until March 25th, and on April 6th, the tribunal announced his verdict. On April 17, 1947, the tribunal sentenced him to life imprisonment. This sentence was notable because it was heavier than that of Albert Speer, who was also accused of slave labor violations and occupied a far more important role in the Third Reich. Milch thereafter appealed to the United States Supreme Court, and that body on October 20th, 1947, denied his appeal for a writ of habeas corpus. The Milch case was the second of the subsequent proceedings to open at Nuremberg and the first to close. Milch was charged with participation in the recruitment and exploitation of slave labor from occupied territories and with the use of prisoners of war in German factories in violation of the Hague and Geneva Conventions governing the treatment of prisoners of war and with the exploitation of slave labor from Nazi concentration camps. On the slave labor count, Milch was convicted largely with his own frequently violent words from the minutes of the Central Planning Board, of which he and Albert Speer were the prime movers, and the minutes of the fighter staff and an armaments conference involving Air Force engineers and chief quartermasters. These minutes showed that he was intimately involved in critical aspects of the slave labor program with Fritz Sauckel and Albert Speer, who were defendants before the International Military Tribunal and who had been found guilty by that body. A special aspect of the Milch case was the charge that he was involved in the exploitation of the labor of 400,000 Hungarian Jews who had been forcibly deported from Hungary for work in the construction and operation of Germany's underground aircraft factories, which Milch was appointed head of this program, which is known as the Jägerstaff program, or fighter staff program, on March 1, 1944. I was deeply involved in the preparation presentation in court of this phase of the Milch case, which proved to be significant in his conviction. I remember distinctly an admission I secured on January 13, 1947, from Xavier Dorsch, who played a key role in the implementation of the Jägerstaff program, that the Hungarian Jews involved in the program were poorly clothed, poorly fed, and that fatality rates were high. In fact, many of the slave laborers exploited under organizations led by Milch and his cohorts died as a result of the harsh conditions under which they lived and worked. Based on the evidence presented at Nuremberg, the court convicted Milch on the slave labor count and sentenced him to life imprisonment. Milch began serving his sentence after the trial at Rebdorf prison outside Munich. But in 1952, his sentence was commuted by High Commissioner John J. McCloy to 15 years, and in 1955 he was pardoned and released from prison after serving 2/3 of his sentence. Characteristic of his own statements which convicted him are several from the minutes of the meeting of March 25, 1944 of the aircraft engineers, at which Milch said that prisoners of war were not being treated with sufficient severity, and that, quote, international law cannot be observed here, end of quote. Referring to prisoners of war, he said, if he has committed sabotage or refused to work, I will have him hanged right in his own factory. I'm convinced that this will not be without effect. Gentlemen, for me, the law no longer exists. If you keep in touch and immediately clarify difficult points so that something can be done, then we're willing to accept the responsibility whether this is the law or not. I see only two possibilities for me in Germany. Either we succeed and thereby save Germany, or we continue these slipshod methods and then get the fate that we deserve. I prefer to fall while I'm doing something that is against the rules, but that is right and sensible, be called to account for it, and if you like, hanged, rather than be hanged because Papa Stalin is here in Berlin, or the Englishman. I have no desire for that. I would rather die in a different way. But I think we can accomplish this task too. We're in the 5th year of the war. I repeat, the decision will come within the next 6 weeks, end of quote. These minutes were quoted in the prosecution's closing statement because they showed the defendant's state of knowledge and intent, and they played a role in the conviction because they're quoted verbatim in Judge McManus' concurring opinion supporting the life sentence that Milch received. Yes, we convicted former Field Marshal Milch at Nuremberg. It was largely through his own words. I think that Milch's remarks are important evidence of a top Nazi state of mind regarding the law. There are many instances where they showed that they knew the law, but chose to violate it and go by their own self-defined rules, which set no limits on their behavior. I'll be candid in stating here today that this throws the charges by Senator Taft and others that the trial violated the principle of ex post facto into a cocked hat. I also wanted to mention other cases which are very important, which our chairman asked me to say a few words about. The Pohl case, which was run under the aegis of Jack Robbins, who is here today, involved Pohl and other SS defendants who ran factories and other enterprises near concentration camps with slave labor. The spirit of the judgment in the Milch case was reaffirmed by the same tribunal in the Pohl case. Here the outstanding feature was the court's judgment that slave labor, forced labor, irrespective of the physical conditions thereof, was evil. Tribunal said slavery may exist without torture. Slaves may be well fed and well clothed and comfortably housed, but they are still slaves. If without lawful process, they are deprived of their freedom of by forcible restraint. We might eliminate all proof of ill treatment, overlook the starvation and beatings and other barbaric acts, but the admitted fact of slavery, compulsive, uncompensated labor, would still remain. There is no such thing as benevolent slavery. Involuntary servitude is still slavery. The next case was the RUSHA case. It was a second SS case in which the defendants were charged and convicted for implementing many features of the Nazi racial program, including the kidnapping of racially valuable children from occupied countries for Germanization, the forced Germanization of other foreign nationals who were considered ethnic Germans, the forcible evacuation of foreign nationals from their homes in favor of Germans or ethnic Germans, and the persecution and extermination of the Jews throughout Germany and German-occupied Europe. In a nutshell, Russia and other organizations put in effect the pernicious Nazi racial myth, which involved weakening and eventually destroying other nations while at the same time strengthening Germany territorially and biologically at the expense of other nations. The hostages case, which is the final case I'll discuss, the prosecution was headed up by Ted Fenstermacher, who's here today, and involves some important legal principles. The hostage case involved generals indicted for war crimes committed in Yugoslavia, Albania, and Greece. The issues involved in this case were whether partisans or guerrillas were entitled to the rights of belligerents and were to be treated as prisoners of war when captured, and whether it is ever lawful for an occupying power to execute hostages taken from civilian populations. In this case, although finding most of the defendants guilty, the tribunal upheld the right of an occupying power under certain circumstances to shoot hostages and denied partisans the status of belligerents. The case has had its effects. For example, the American Army Field Manual now provides that hostages may not be taken, and for the protection of the civilian population and prisoners of war, it accords a legal status to members of a resistance movement and to partisans. Moreover, in 1949, the Geneva Convention was amended by adding a provision to prevent the taking of hostages. Important advances in international law. In sum, the decisions in the Milch and other cases which I've described made an important contribution to the development of international law by implementing the principles of the IMT judgment in other cases involving related and varying factual situations, and they remain an important inheritance of Nuremberg. Hats off to Telford Taylor for his leadership role in the subsequent proceedings at Nuremberg. I have 2 minutes more.
You have.
Okay, the legacy of Nuremberg.
Make it 5.
Okay. The legacy of Nuremberg. Nuremberg represented the most impressive moral advance emanating from World War II. First, Nuremberg held that individuals responsible for violation of international law, and correspondingly that individuals had international human rights not dependent on nation-state recognition. This was a great leap forward in the evolution of a civilized world. Second, and closely related, it marked the real start of the international human rights movement because of the first international adjudication of human rights. Its effect in this respect is felt today throughout the world in the UN's Universal Bill of Rights, the American Convention on Human Rights, and above all, the European Convention on Human Rights and Fundamental Freedoms, which is a direct legacy of Nuremberg. Third, the UN tribunal currently sitting at The Hague will be trying individuals such as Tadish for crimes which are directly parallel to those with which Nuremberg dealt. In fact, the crimes against humanity and war crimes on which the Hague Tribunal is focusing are a direct inheritance of Nuremberg. But here we need to remodel the Hague Tribunal into a permanent structure which would cover aggression as well as start afresh and reestablish, or start afresh and establish an international tribunal of universal jurisdiction which would deal with Nuremberg-type crimes. If some surrender of national sovereignty is involved to make it work, so be it. We have already waited too long to institutionalize Nuremberg. Fourth, Nuremberg principles covering the conduct of war incorporated into all the field manuals of the major powers, and the Nuremberg principles have been supplemented as needed by the 1949 Geneva Convention covering the treatment of prisoners of war and the protection of civilians in wartime. Fifth, Nuremberg was the first post-mortem analysis of a dictatorship. Through Nuremberg, we learned the intimate details of the levers of power in a functioning dictatorship. Hopefully, we can avoid dictatorships in the future and thereby most aggressive wars because, in my view, democracy and aggressive war are antithetical in nature. For the future, we need to institutionalize the principles of Nuremberg. We need to build institutions which will enforce them. Institutions which will outlast individual human lives, which will be there for future generations to live under. Nuremberg was right and just. Let it be a beacon light for the world to see and revere now and for eternity to ensure a better future for all of us. As Edwin Dickinson, that great internationalist, has said some years ago, history teaches that without ideals there can be no progress, only change. The stars that guide you may never touch with your hands, but following them, you will reach your destiny. Let us all here today tithe a bit for future humanity and endeavor to create for future generations a more secure world in which the rule of law prevails and a lasting peace is institutionalized. For me, Nuremberg remains a vivid memory which will live with me always. It gave my life a sense of meaning and purpose, and I became an individual. I resolved never to let horrors like those of Nazi Germany happen again. And I have devoted my life to that quest. Thank you.
On the list and enunciating them for you, I want at the beginning to thank those who have not been adequately mentioned, and that is all of you who are here, the translators, the analysts, the researchers, the librarians, and all of those who made it possible for the prosecution to receive the documentation that was necessary in order to obtain the convictions that were obtained. You'll recall that Professor Telford Taylor, who set the guiding lights, was determined that these subsequent proceedings would expand on what was only touched upon in the International Military Tribunal. In a brief trial of only a limited number of defendants, it was quite impossible to portray the entire panorama of German organization and German life which made it possible to commit the greatest crimes that had ever been recorded in human history. And so the difficulty was, how do you decide who is to be tried? And how do you get the evidence? Because in order to obtain a conviction, you need two things. You need, first, evidence of crime beyond a reasonable doubt within the framework of the Charter of the International Military Tribunal, to wit, aggression, crimes against humanity or war crimes, and you need the defendant in custody. If you have one and not the other, you cannot proceed. And in order to put these two components together, it was necessary to obtain the cooperation of large numbers of all of you. The staff exceeded 1,000 people at one time, in order to move forward on these 12 different trials, sometimes by chance, sometimes by plan in advance, which didn't turn out to be so good, as Walter Rockler pointed out to you. He was sent in, assigned to collect the evidence and prepare trials against the bankers, the Dresdner Bank and the Deutsche Bank. The Dresdner Bank and the Deutsche Bank have always been very prosperous. No one was ever convicted of bankers in that line, which has cast sometimes he begins to doubt the utility of some of our exercises, and I can understand it. Fortunately, Henry has covered for us the military and SS trials. Belle dealt primarily with the I.G. Farben trial, which was a very important trial, and noted particularly that it was I.G. Farben that built the Auschwitz concentration camp. They planned it, they financed it for the purpose of using and abusing and working to death the slave laborers whom they employed in the Bonne plant. These facts were disclosed at I.G. Farben. We had other industrialist trials against Krupp. No one has mentioned the Krupp trial. We've been falsely accused of trying the son for the crimes of the father. Absolutely false. Krupp Jr. had taken over the management of the company. He should have been the one indicted and considered in the first trial. But he wasn't, and his father was senile. And so we proceeded to indict the man we should have indicted in the first place. We also had a trial against Flick. Flick got off fairly easy. But he, like the other industrialists, were part of the conspiracy to take human beings and instead of just murdering them, as the Einsatzgruppen had done, where I was the chief prosecutor, but work them to death. It's much more efficient. We dealt with that in a book called Less Than Slaves. And they were less than slaves because a slave is someone whom you preserve and try to use. But as one of the survivors of Auschwitz described it, we were less than slaves. We were like a bit of sandpaper, rubbed a few times and then thrown away to be burned with the garbage. All of that is described in the book published by Harvard University, the introduction by Telford Taylor. The Germans made a television show out of it. They translated it into a book called Vernichtung durch Arbeit. The Japanese translated it. I can't give you the Japanese title, unfortunately, but it is being used in Japan by the comfort women who were abused by the Japanese. And they found in that book the moral principles and the legal principles stemming from Nuremberg, which they hoped would obtain compensation for them. And one thing which has not been mentioned is the survivors. What about the survivors? I stayed on in Germany for 10 years, 8 years after the Nuremberg trials, in order to set up the restitution laws to compensate those who had survived. And it was a very complicated and difficult thing, too difficult to elaborate here. But as a result of that, the West German government, now the German government, will have spent over 100 billion marks in providing pensions for the survivors and some minimum compensation for those who survived Auschwitz. The amount they got was 5 marks a day, then the equivalent of $1 a day. Not much. But it was something, more than the industrialists did. Telford Taylor criticized them in the introduction to the book, because the arguments they made, like the Japanese, were, if it hadn't been for us and providing work for them in our camps, they would have been destroyed immediately by the Einsatzgruppen or directly in the extermination factories. So we saved their lives. What do we owe them? They owe us. This was the type of argumentation made by serious, leading German industrialists, defended by such competent defense counsel as Dr. Kranzbuehler, who today takes the airwaves and says the whole thing was a mistake. Well, let me just mention one more thing, because just as I have intimidated Henry King into keeping the schedule, Drexel Sprecher, who's a little bigger than I am, intimidated me. He said, talk a little bit about the resolutions. We have some resolutions which I have been ordered to introduce to you sometime later this afternoon. He will inform me. We'll have time for questions. These two resolutions deal with two things, and they relate directly to what we have done. One is support of the United Nations. While we were busy at Nuremberg, the United Nations was being formed in the United States. These two operations went on simultaneously with very little contact between the two. But the United Nations was designed to put in place the system which would make it possible to avoid the type of crimes in the future that were the subject of the Nuremberg trials. The United Nations Charter has several defects in it. It was as far as they could go politically. Politically, it was not possible to create a court with permanent jurisdiction, to have compulsory jurisdiction over disputes between states, or an international criminal court. There were other things. They couldn't set up independent financing, for example. These defects have hindered the work of the United Nations, and our resolution dealing with that calls for honoring the Charter of the United Nations. As lawyers, we know that's a legal document, a treaty accepted, ratified by the United States, part of the law of this country and all the other countries, and systematically ignored in some of its fundamental requirements for disarmament, economic sanctions, international military force, etc. We address those briefly in the resolution. And then the second resolution calls for the creation of a permanent international criminal court. That is the logical consequence of what was done at Nuremberg. As Telford Taylor has pointed out in his recent book, The Anatomy of the Nuremberg Trials, law is not a one-way street. We were not trying to impose law against the Germans, or against the Japanese, or against anybody else except those who commit the crimes, whatever their nationality, wherever they may be, whenever the crimes occur. Not limited merely to Yugoslavia, not limited merely to Rwanda, but wherever they happen in future at least. Aggression, war crimes, and crimes against humanity must be recognized as international crimes, subject to international courts, and subject to the deterrent effect of judgments under law. That's what it was all about. That's what you're all about. That's what our future is all about. And my time is about run out, so I bid you goodbye.